Good evening. This is the Wolfeboro Planning Board meeting for Tuesday, June 17th, 2025. Sorry, that was a little interruption there. This is the Wolfeboro Planning Board meeting for Tuesday, June 17th, 2025. My name is Doug Breskin. I'm the chair of the Planning Board. To my left, we have Vaughn Dugan, Peter Goodwin, Roger Murray, and to my right, Select Board Representative John Thurston, Nancy Wiley, Jane Nielsen, Kathy Barnard, and Julie Jacobs. You hear that?
She's plugging in her computer.
Stop doing that, please. No.
All right, the first item on the agenda is a discussion item for Capital Improvements Plan Member-at-Large appointment. We have a request from Suzanne Ryan to join the committee. Suzanne, would you like to speak? Would you like to come up and speak?
You're going to have to turn the mic on.
Turn the mic on.
Is that working? Yeah.
Yes,
okay.
it is.
No, I just came in case there were any questions you have. I've been on the CIP for approximately a half a dozen years. I find it extremely informative as to the town's 10-year plan and what direction we're going. And I will be quite frank with you, I'm very concerned about water and sewer this year, and I don't think we've been paying enough attention to it, so I'll be looking for that on the department heads'
Thank you,
submittals.
Suzanne. Thank you. Does anybody on the board have questions for Suzanne? No, then I'll make a motion to appoint...
Just a second, because we do have, the reason that we didn't appoint Suzanne as a member at large was because she just recently ran for the Budget Committee and is now on that. And our rules of procedure for CIP is that it's supposed to be one Board of Selectmen meeting. This is a planning board committee. And so it's supposed to be one Board of Selectmen member and one Budget Committee member, and 2 planning board people and 4 members at large. And so that was the reason we didn't appoint her. However, in this case, Suzanne has been on the CIP for a number of years, and she may be on the Budget Committee, but she also is familiar with the procedures and has been very knowledgeable as far as I'm concerned. And so anyway, I just wanted you to know the background.
I appreciate that. Thank you.
Okay, thank you.
So
I
we
have a
weren't,
question.
we weren't bumping a spot?
I'm sorry. Hold on a sec. Julie, go ahead.
We weren't bumping a spot for Suzanne to come on?
No, that we advertised, and there were 2 people that indicated an interest, but then they both dropped off. And then Suzanne also.
Yeah, to my knowledge, Suzanne is the only remaining person
Yes,
expressing
right.
an interest in this position. Vaughn?
Well, is my mic working? Yes.
It is, I think.
How many members at large are there now on the committee?
3, and there's actually 4
Spots.
sections
positions.
for citizens.
Yeah.
So, concerned allayed.
Very good. Any other questions?
I
or-
guess my concern was she's on other committees, and does she have time to do this? But she seems to be the Energizer bunny in this kind of area, so I think it'll be okay.
Yes, I think she's very committed. All right, so I'll make a motion to appoint Suzanne Ryan as the member at large to the CIP.
Second.
Second, all in favor?
Aye.
Any opposed? Very good. Thank you, Suzanne, for your service. The next item on the agenda is Brewster Academy site plan review. We've been informed that they will not be here this evening, and I'd like to make a motion to continue their hearing to July 1st here at Town Hall at 7 p.m.
So moved.
All in favor?
Aye.
Aye. All right. They'll be back here on July 1st. Thank you. The next item on the agenda is a preliminary consultation for D&M Homes Special Use Permit after the fact, 9 Christopher Court, tax map 143-017. Was somebody here to speak for the applicant? Peter, if you could introduce yourself into the microphone so we have it on the record.
Peter Cooperdock, Fernstone Associates, working with Sean Dunn of D&M Homes. Okay, so this situation is, I guess, evolved since the meeting the other day. And I got to eat the microphone.
If you could maybe
Yes?
raise it up a little bit.
Okay, these
There we
things
go.
make me very uncomfortable, okay? So I just was told to come here and try to decide a path forward for this. I thought we had made a resolution to accept the steps and deck, but now the question just is the improvements that have made to the property in the wetland buffer zone, correct? Am I on the right track here?
My understanding is that at the last meeting, yes, we approved the deck and the steps.
Yes.
We did not address the fill that was put into the buffer zone, as that was not part of the application.
So we're trying to resolve that aspect?
The planning department here made a recommendation as one of the ways forward to ask for an after-the-fact approval for putting the fill into the buffer zone. That was my understanding as to why you were here this evening.
Okay, just trying to get clarification on what exactly how we're going forward with this. So this would be a continuation of the original application with supplemental information?
No, this is
Or we have to
separate.
go through a whole new application, 30-day wait, be August?
My understanding is this is separate from the previous approval.
Okay, and my question would be, why does it have to be? Why could not just be this expanded, take the approval that was offered, presented last time, and things have many times been added to an application in process as the application is reviewed. It'd be, I think, behoove everyone involved to get this resolved as quickly as possible. If we could move forward at your July 1st meeting with a new plan and a new supplemental request, I think it would be helpful for everyone involved, instead of delaying it for another month.
I don't know that that's possible from a procedural standpoint. Leanne, do you know if that's possible? I would assume not.
The abutter notice is not possible.
Microphone, please.
It's not possible with regard to abutter notification and notice in the newspaper.
Yeah.
I can't meet the deadline.
Okay, well, I do have a comment, if I could, on that, because it was advertised, and this would be, from my perception, this would be a continuation of the last meeting. I just want
No,
this to be
understand what you're
discussed.
saying. I understand what you're saying.
Rather than shaking heads and saying no, I would like to have opportunity to have it properly vetted so that we can, all understand what we're doing here, okay? So from my perspective, this would be a continuation of the last hearing, when you did Brewster's, are you re-notifying every abutter every month?
No, the procedure, and using Brewster as an example, at the public meeting, which was properly noticed, if it's continued, we announce at that meeting that it
Yeah.
would be continued so that we don't have to send out new notices.
Yeah.
In the case of, that we're talking about with you now, we concluded the business at the last meeting, and there was no notice made or announcement made at the last meeting that it would be continued to this evening. And therefore, the abutters have not been noticed or had an opportunity to come and speak to this application or potential application.
And
which
there
is
was
why-
a vote taken also.
And there was a vote taken also, that's
Okay,
correct.
I just wanted to be able to be clear on that, because from my perspective, it would be a lot simpler if we just got this done, next meeting. But-
So from a procedural and legal standpoint, we would have to renotice all the abutters so that they would have the opportunity to comment on any proposals, changes, whatever might be going forth in the business of hearing this application.
Okay,
So, and my understanding as the issue is the fill installed right to the edge of wetland. And that's a violation which was discovered at site visits the night of the hearing. So I would think that there would have to be some reclamation or solution to the violation that's occurred, that was discovered.
Yes, you're correct. And one of the things that potentially would be presented here this evening as a potential solution would be, as it says in the agenda here, to ask for an after-the-fact approval of having that fill installed so that they would not have to remove it. And so my understanding is that Mr. Cooper, Dr. and Mr. Dunn, we're going to come here and essentially take the temperature of the board to see what our feeling was about approving that fill after the fact. Is that an accurate representation?
That's my understanding of it, yes.
Yeah.
And what would be, from, if we can't have it ready for next meeting, then for the August meeting, present a new plan showing the existing conditions as today with some improvements, because right now it's bare soil, and the slope to the wetland that's there is unstable, needs to be addressed, needs to be stabilized. Basically, I'm having concern, one of my interests for trying to hasten this is because he can't do anything until this is resolved. And there is bare soil there that is going to be unstable, and if we get one of our famous thunderstorms, we could have damage to the wetlands, and it's an inadvertent thing. So we're waiting 6 weeks to be able to resolve this before you can do anything to bare site, which was going to be addressed by now. Okay, so this it's a concern to me.
Yes.
Okay. So.
John?
So Prudence, Mr. Cooperdock would say that if you thought that there was erosion potential, you would go out there and you would try to stabilize the area as best you could in order to maintain that window before the next meeting. And I would suggest you go out there and put some turbidity control on the edge of the area that you have filled in, because that was noticed at the first meeting. There was no siltation measures in place at all, and that was a requirement initially. There was no silt sock, there was no silt fence, and if you wanted to do prudence, you would go out there and you would spread mulch hay on the area to minimize the erosion aspect of that ground.
As long as that's okay to do, we can certainly do that. I just want to make sure we're not going to get in trouble for doing additional things. But if that is okay with the board, we can certainly stabilize the site with erosion control measures. Yes, if that's fine, we can do that.
We can discuss that further tonight, but
Yeah, okay.
that would be the recommendation.
That would seem like an appropriate solution to do that. Okay, so what I would like us to be able to do is present to you at the August meeting a plan of showing existing conditions and proposed measures to address some of the slope areas that wasn't finished. Right now, there's a series of arborvitaes that were planted approximately 10 feet from the limits of the wetland. between them and the wetland itself is a series of boulders that have been piled from various stages in the work that would be removed. The slope would be stabilized and seeded, and that would become a buffer area that would be allowed to revegetate, and the open area next to the house between the arborvitaes and the house would be proposed as a lawn for the people to live there. That would be our intent. It's also the extent of the arborvitaes could be increased further along the edge limits of the wetland up into the 25-foot setback area, and then, you know, thereby maintaining a solid buffer between the residential area of the property and the wetland itself. There'd be a minimum of a 10-foot buffer. And I've done many special use permits here in the past with many of you people here, and have offered 10-foot, 7-foot vegetative buffer maintenance along the edge of the wetland. So this would be basically along the lines of those other applications that were approved by the board in the past. So from my perspective, it would seem that we were recreating a 10-foot vegetated buffer minimum along the edge, and then the rest would be retained for the family's use.
Roger?
In order to get a special use permit, you do have to meet the requirements under section 175-10C1, A, B, and C. And the one that would seem to be the most problematic is B, which states the proposed construction is essential to the productive use of other land which is not within the Wetlands Conservation Overlay District.
And how is that contradictory to what it would become? This is a home. This is going to be somebody's house. Having a lawn and a yard is part of the enjoyment of a person's property. So it seems like that qualifies.
I have trouble with it. I think that usually comes into play where you're trying to cross a wetland to get to a building site.
Well, also, there's been many times where we've had special use permit applications here where a building could possibly fit within in the 30-foot setbacks, but a perimeter area was allowed around that, so for the use of the family, or the buyers of the property.
I don't remember ever giving extra privileges to fill in a buffer area with yard, ever. And I'm concerned about the precedent that we'll be setting here. If you go and fill in the buffer and then come back to us, it's all fine. This is our issue because it's all...
Okay.
So I have a big problem with this. I just think this is a violation and it needs to be restored. And they don't need a yard. They're buying a house next to a wetland. They should appreciate the wetland.
Another question for you.
I have difficulty with that line of reasoning. For one thing, such a situation has never come up in my experience where a house that met compliance was required to get a special use permit for impacting around the buffer. We discussed this the last time we were here about whether this lot was a grandfathered situation as far as the wetland buffer or not. It's just never happened. This is the first time. Now that everyone is aware of this, perhaps care will be better taken on the town staff to make sure that this is complied with. But this is to me, this is a one-off. We're not looking for setting a precedent for allowing impact to buffer zone. It's always been my understanding, and working with the town for the last 30-some years, that these grandfathered lots had a different status than newly created lots. There's setback differences for old lots. There's all kinds of dates in your regulations talking about different standards for non-conforming lots. And this would appear to me be a non-conforming lot.
I would be
way.
curious to see the original approved plan showing the buffer to the wetlands.
Do you mean when the lot was
When
created?
the lot was created and the building site was approved, to see what was allowed, because I'm surprised if we allowed it to be filled right up to the wetlands.
The subdivision plan shows that it's not a non-conforming lot. It's in excess of 1 acre, and there is no delineation of wetlands or building sites on the plan. It was approved in 1987, and under the wetlands ordinance for lots approved prior to 2003, I believe it is, there is some flexibility in terms of constructing the house and a limitation of 1,800 square feet, but this is not a case where the house is in the wetlands.
It's not, no, but there's instances where there's older lots are, as you said, given different circumstances and allowed. And it's the way the staff has operated up until now, that these circumstances has never been a concern in the past. And so it's hard for me to call this a precedent when this was a situation where someone innocently had multiple visits from town officials that would have been opportune for the town to make a case that he had been in violation, until he comes in willingly looking for a patio for the people that are buying this house, and now is realizing that there's an uproar about a violation, which seems like inappropriate for a situation that was done in there was no interest in violating any ordinance. It happened and it was discovered. I think it would be appropriate to resolve this situation in a amenable way, and not view this as a precedent into the future, but allow it to be an example of, if this is the way this ordinance is going to be enforced, that it be done in a consistent way into the future, because it hasn't been done in the past. And you could research other lots around town that have not followed even special use permit provisions, to say nothing about other lots that didn't have to come into this.
Do you know of any examples?
I am not going to reveal any of my information. I'm
Okay.
sorry. Nice try. Appreciate that.
Well, I'm not suggesting what your prospects for success are, but you might want to look at the equitable waiver provisions of I think it's 674-33A of the New Hampshire statute, which provides relief from setbacks. And then you would apply to the Board of Adjustment, and whether that would be successful, I have absolutely no idea, but it is an available alternative.
So I wrote a little something up because I've been intimately involved in this. T&M Homes, represented by Sean Duane, request after the fact. I'm sorry, excuse me, done. Request after the fact special use permit fulfilling the wetland buffer setbacks area that total area is unknown, but is more than visible at the site visit on June 3rd. What was noticed was no turbidity or siltation measures at all. Wetland buffer from the edge of the wetland to the 25-foot line was filled.
on multiple sides of the property. Yes, there were conservation recommendations for plantings, but the understanding is that those plantings were to be in the natural ground area, not in any filled area. Also, the applicant installed the plant items before the application was approved by the planning board for development into this wetland setback area. The soil scientist representing the applicant questioned the regulation. In New Hampshire, the law requires that the wetland permits for wetland buffer zones, which are areas adjacent to the wetlands, these wetlands are regulated to protect the wetlands and the ecological functions of the water quality. Filling within the wetland buffer setback without authorization would likely be considered a violation of the regulations and could trigger enforcement actions. A brief conversation with the town manager was discussed by myself to see whether the codes officer had acted in estoppel. He is the one that signed the violation letter along with the attorney for the town of Wolfeboro. So therefore, his thought was the town's codes officer did not act in estoppel. The Board of Selectmen are the enforcement authority of the town of Wolfeboro. I am an ex officio member for the town of Wolfeboro as a selectman's representative. To Mr. Dunn's letter, a member is pushing this. I'm an elected member, ex officio. I'm not pushing anything. I noticed the situation along with my fellow colleagues at the site visit. No, just 1 minute. The fact is that the motion to allow the process to play out with Mr. Dunn wishes to go for an appeal, he may. The Conservation Commission should weigh in on the discussion and what their intent is on this application. You may speak, I'm sorry.
Thank you. Sean, could you introduce yourself, please?
My name is Sean Dunn. I'm the owner of D&M Homes. John, you found it amongst yourself after the board voted here, 3-3-1, not to seek a violation. You went and did it on your own to do it. And as far as I'm concerned, you probably shouldn't be sitting in this. You should be recusing yourself from further on it because of the way and how much you've pushed on this. I don't know what your problem is with me and why you've pushed so far against me on this, but it's clearly biased, in my opinion.
Mr. Cooperdock, on the original application that we addressed at the previous meeting,
Yep.
you submitted a plan for developing the pervious patio.
Yes.
On that plan, it shows elevation lines. And I'm
Yes.
wondering if those elevation lines show the current
No.
filled or the original.
That's the original. Those are the original, because they go through the building. Okay?
Yeah.
That's the original topography from the lot. What I propose to do is get the current topography, compare the differences to it, and depending on how this works out tonight, present a plan for the restoration, alteration, acceptance, however we go with this. The arborvitae trees that are shown on the plan are suggested locations. They're not the actual locations. So
All right, so the reason I bring that up as a point is that for those members, both of the Planning Board and the Conservation Commission, who reviewed these plans without having a site visit, I think it was reasonable of them to assume that the elevation lines shown on this plan would be what they would observe had they gone out there. And I assume that it would also be expected that whoever was doing your site work would follow those elevation lines as well.
well, I'm sorry for that misinterpretation, but it was based on the original topography and the original septic design. It wasn't an updated version. And I have every application I've done has been, well, of course, this was a project that was in stream when this idea of a special use permit was proposed, so.
Doesn't filling in a wetland buffer require DES approval?
The state of New Hampshire has no setback requirements for any impact to wetlands. This is one of the few towns that do.
Yeah, my understanding is that's correct, that certainly the state would regulate anything in the wetland, but the actual buffer is a Wolfeboro ordinance rather than a state ordinance.
That is something that's important to consider here, because, you know, these are regulations that are out of the ordinary for most of the state. You have a right to put these additional regulations on. The enforcement of them is something that has been apparently not within the desires of the planning board.
John?
So the reason why the town puts these regulations in, and there was endless hours with the subcommittee going over these recommendations. And the reason that they put them in is to allow the water to dissipate before it gets into the wetland. And what also was happening here is where you built that area up, that area doesn't dissipate into the buffer setback before it goes into the wetland. That actually changed the elevation, and now that water goes straight down the hill, and that goes into the next guy's property. And the idea is for allowing those waters that come off of your area that's allowed is to seep into that buffer area before it gets to the wetland setback, and to allow that natural structure and that ground cover to grow and be natural. And so that's the intent.
I understand the intent, and the intent is to prevent impervious surfaces, runoff from impervious surfaces, to have an opportunity to be absorbed. We're not talking about putting any impervious surfaces besides the 12 square feet that was approved at the last meeting. Anything you put there is going to absorb runoff, water. It's going to be a lawn, like anybody's lawn anywhere absorbs water. It's not impervious surface. You depend on, I know you're smirking, I don't know why, but you know, your lawn will absorb rainwater. You know, it's there. It proves it has a function in treating and absorbing rainwater. The difference between a forested area and a lawn, there is a difference. A forested area, because of the duff, is going to absorb it to a greater extent. That's why I would propose to have a perimeter, maintain a perimeter around the wetland to do just as you suggest. I'm not talking about having lawn right up to the edge, though you can see that in many locations, and in many locations around town, the lawns are the wetland. But in this case, we would attempt to recreate an area that would regenerate into a natural buffer area while leaving a 15-foot area around the house as a lawn for the people that are going to buy the property. The practical use of a property with 5 foot of forest out your back door, why do we have this deck there then? You know, so that's part of it as well. And it defies logic to think that you both would want to restrict someone from that kind of use of their property while the functions that you're discussing here are going to be maintained anyways.
So to that point, the same night we saw a different application on Fawn Haven.
Yes.
Down at the end of Fawn Haven, there's another house, and the example was you could see 5 feet from the house, there was a clear cutoff, and then the wetland buffer setback, and it was all natural vegetation right up to the edge of that 5 foot away from the house.
That was a wetland 5 feet from the house. I did that application, presented that to the board. That was what was approved. There was a wetland at 5 feet. There was wetland that was filled to be able to put that house there. There's a lot in between those two houses that was approved by this board to fill 2,600 square feet of wetland to be able to construct a house. That was approved by this board.
I'm responding to your point of it's illogical. It's not illogical to have a cutoff 5 feet from the house.
It's, well, that one was actually 7 feet, but anyways,
Okay.
that was a special circumstances because it was an actual fill-in wetland. We're talking about a different series of circumstances here than a upland area that is near a wetland, and the protection of the function of the wetland will be maintained with a 10-foot buffer.
You know, one of the things I would recommend is we have, as you know, in Wolfeboro, a Conservation Commission that serves as an advisory to the planning board here. And I would think that the planning board as a whole would be reluctant to move forward on anything without feedback from the Conservation Commission on the plans that you're proposing.
That's a reasonable request, yeah. Yep.
Can I just ask a question since I didn't make it to the site visit? On the back of our little sheet here, it says, in order to come into compliance, please either, and number one, we haven't talked about it at all. It says, remove the fill, return the area to its pre-existing grade, and reseed. That's what number one says.
I haven't seen this, so I don't know what you're referring to.
That was the letter from
I
the
have
town?
not seen the letter.
Oh.
Did you get a copy?
Well, so I know that Mr. Dunn received the letter, and I'm aware that Mr. Dunn has some concerns about how removing the fill might affect the structure. Would you care to speak to that? No. Okay.
Okay, that just, you know, seeing number one and number two, that just seemed like an easier go of it than number two, that's all.
You need to go to the microphone. I was going to say anything.
It is and it isn't, because 5 feet off the house would be much higher than any other lawn. If that's the way the board wants me to go, that's the direction that we'll end up going.
Was that what the pre-existing grade was 5 feet down?
Well, the house is 30 feet off, so it'd be 25 feet in, but I got to maintain the footings in the foundation of the house, so I've got to keep a backfill coming into that house to keep that all back in. So I'd have to bring it 5 feet out and then slope it down into this 25-foot area to bring it down back in. To go back onto the point of estoppel that you had brought up, John, this building inspector did not issue the permit. It was Jason who issued the permit, and Jason was the one that told me to come to the planning board for the pervious patio to be brought back in. When I had a conversation with Peter about this, Peter specifically said that he's told many, many towns in his past before, as being a municipal building inspector, that it's impossible to build a house with only 5 feet off the back of the house, to be able to do it with having the setbacks in the front of the house and the setbacks off the back of the house. But that's what he specifically said to me last week. The estoppel was because of what Jason had done, not what the current building inspector done. Jason was out there, he saw the backfill, he saw the area filled in, he was out there doing at least 10 inspections. That's where I have the issue on it, not with Peter, the building inspector, now.
So to that point, it wasn't about Peter, the new building inspector. It was about Jason specifically. And the town, yes, and the town manager specifically pulled out the recommendations for approval. The final drawings, each sheet of every sheet drawing must include a certified wetland scientist stamp, and a final version of the narrative letter shall include certified wetland scientist stamp. The application should submit the following: two sets of 24 by 16 black line final approved plans, one set 11 by 17 final approved plan drawings, one electronic version PDF format. So in the final version, that would be a recommendation for the approval, and that was on the planning board packet. So at least you would have had to submit the final plans for the planning board for approval.
The as-built plan was signed off by the current building inspector with this information in hand now for the septic design. The building inspector had been out there, the current building inspector out there was out there when he saw the frame and saw all the information there. So the municipal estoppel was he had plenty of ample opportunity to talk about that 25 feet. That's what I had argued about that 25 feet, that the building inspector had plenty of time being out there. The home is at a completion stage now, and the violation is being issued. That's where the municipal estoppel is coming in. They had plenty of opportunity. I went in numerous times, Leanne can probably attest to it, to talk to Jason and ask him what needs to get done about a larger deck or a larger patio, or what needs to get done, and that's when this came about, that I needed to do this. Nothing ever talked to me about the 25-foot buffer zone. Not with Jason, not with anybody.
That's the responsibility of you and your applicant to follow the regulations.
Sir, Jason is the code enforcer.
He's the building
As a
inspector.
citizen, a taxpayer, and a contractor working in town, we have to rely upon the building inspector. We have to. If we're not going to be relying upon the building inspector on anything, then how do we actually work in town with it? Because every town has different regulations. So you ask questions to the building inspector, and that's what we did numerous times.
Any further comments from the board? All right, so,
Well, no, I have one.
Yep.
You know, I don't know, and the question I ask may be completely irrelevant, but is there documentation as to when this fill was put in, whether it was put in before or after, when the last time the building inspector was there?
Before. So there's actually less now from when it was. It was graded down and brought back in. But when the house foundation was all dug out, all the fill was filled down into that back area. That whole back all went into that area. Then the backfill went back into the house, and then it was all graded coming down. So it was when the foundation was done back in late November.
I want to stir the pot just one more time. How far along with the house and everything are we done? Do we have an occupancy permit? And did it come back just for the steps for the deck?
we do
So
not,
we have a stop work order. I can't get an occupancy permit unless we have a decision here or the stuff is done. The closing was supposed to happen last Friday, but everything is on a stop now. So the buyer is actually, I've got a letter to the building inspector, which was bringing it to town manager and town council to ask that we have a temporary occupancy permit until this is settled here. I've offered to put a $20,000 bond up, a $10,000 bond up, but we revised it to do a $20,000 bond up in case the board votes against it, and I have not received any response from anybody.
This seems like way outside our purview at this point.
I'm not sure that it is.
You don't think so?
I don't think so.
And this is just, as we said, a preliminary. The applicant's trying to determine how to move forward, whether it be with the planning board, the ZBA, restoring the site, trying to find out how we should proceed and what his best course of action is.
How to fix it?
Well, I don't know if fix it is the right word to use, but how to resolve the situation. Yeah. So, Mr. Cooperdock, you have more comments?
I would just like to know what the direction of the board is. I've heard all kinds of, comments, haven't really, from like rip everything out to the 5-foot line to, well, that's pretty much all I've heard, which just doesn't seem a proper approach. I would
Yes,
like to find.
I can't speak for the board, but
But the board can speak for
No,
itself.
I understand. I understand.
I would like to understand, we're willing to do what seems like a reasonable thing here. The idea of building a house 5 feet from a forest. fully stocked forest seems dangerous, harmful to the building. You know, it comes into question the applicability of a 25-foot buffer, because that's just, if that's the way it's going to be adhered to, that just seems like an impractical use of the property.
John, I understand your concern.
And I would like, you know, so is there any way to get some kind of, you know, understanding on what we could offer for this special use permit?
That's what I'm trying to explain.
Yes.
So for myself, I'd like to get feedback from the Conservation Commission on their assessment of the situation before I would form my own opinion.
I think you should look at section 175.10C and see whether you feel you can meet those criteria. And I think you should also take a look at the equitable waiver statute.
Okay. Okay. Well, I appreciate that.
Can we back up one more step and let me ask that what we did last meeting that I didn't vote on, to approve the steps into this section, is that still valid?
Yes.
Yes.
That's been done. That was approved.
Okay.
So my opinion is that we allow the notice by the town manager and council to move forward with number one. And if the applicant doesn't wish to follow that process, he has the right to go to the ZBA. And from that point, they can make a determination and he can go from there, and then he can come back to the board.
Any other comments from the board? Mr. Dunn or Mr. Kupadoc, you have any other comments for us?
So the question was just raised that the stairs were just allowed to be put into this area, but at the same time, that was voted on. Now you're telling me I have to remove that area?
No. No,
You just said that.
you were approved for the 12 square feet in the wetland buffer setback area. The board voted on that and approved you to build the stairs in the wetland buffer setback area.
And that
The
still
board
stands.
also voted, John, okay, that you had made a motion to send this for a violation to town council and to the Lakes Region Planning Commission. And the board voted against that. And then it was discussed about municipal estoppel. It was a 3-3-1 vote. And then it was discussed about municipal estoppel that was going on in that particular area and what had happened there. So I left the meeting under the full impression that the stairs could go down into that area and leave things the way they were. Nothing was ever said to me anything different. And the next morning, you created a whole havoc on it.
I don't recall it being leave things the way they were.
No, so it was very clear that we were at that meeting addressing the pervious patio and the stairs. We were not addressing the fill either positively or negatively. We did approve to have the stairs go into the buffer zone. We didn't determine what the elevation of the stairs would be or how long they would be or anything like that. And because the fill that was put in there was not part of the issues we were addressing that evening, it was left unaddressed. That's not an implicit approval, that's just an open issue from our perspective.
And we discussed having a problem with the fill.
Yes.
So there was a discussion about having a problem with Phil, I agree with you there. But then it was a motion to send it for a violation and to bring it back in, and that motion failed.
No, the motion was to deny the application because there was a pervious patio in the filled area. It was a 3-3-1 decision which failed, and then another motion was made to allow you to build the stairs with an exception in the 12-foot square feet for the wetland buffer setback area. And I voted approve that.
You voted abstain to that. You abstained.
Okay, abstain.
But the vote that went in part of your motion, sir, was to hold me in violation and send it over to town council and bring it back for review on July 1st to see what they had said. And that motion failed.
Now, John's motion it was moved by John Thurston to deny the D&M Homes LLC special use permit. That goes to the application based on the site visit and the neglect of filling in the undisturbed location of the wetland buffer setback more than 25 feet. That was a 3-3-1 vote. And then it was moved by Steve Webster to approve the D&M Homes LLC special use permit application plan as drawn except for the impervious patio area. Those were the two motions.
And I'll just, after Roger read that, I'll say that included in the plan as drawn were the elevation lines that I previously mentioned. So I think it's up to you to determine how you'd like to proceed. I can't say that you're going to have success one way or another, or how things will work out. As I said, from my perspective, I'd like to get the feedback from the Conservation Commission. And then Roger had some suggestions that he made to Mr. Cooperdock as well.
So if I decide to leave here today and go there and start working in that area to remove that fill, am I going to be held in a violation for working in that area?
I don't know the answer to that.
This board needs to answer that for the building inspector without holding me in a violation for doing exactly what they want me to do.
On the back side of this letter, it does say, remove the fill, returning the area to its pre-existing grade and reseeding with conservation mix, subject to inspection. That's the back of this letter.
But Mr. Dunn said that there was a stop work order, is that right?
Yeah, so you can't have
Well,
both.
he said that a violation is, under his idea, is a stop work order. Under his, I shouldn't say idea, under his impression, it's a stop work order, and only town council and town manager can give me a temporary occupancy permit if I decide to bring this to the board and move forward.
I can only say that I would be surprised if somebody held you in violation for trying to follow the recommendations that were issued in the letter that you received.
John, can you speak to that?
So what my interpretation here is that the wetland buffer setback area, the amount of area has not been delineated. I do know that the wetland buffer setback on the left-hand side of the driveway was right up to the edge of the driveway.
Well, we'll speak to that, because I talked to Peter about that, because that was a new line, and that flag was put up there delineating the other lot next door in error. He can attest to that.
So
I
I'm
am
just
25 feet in that area.
So what
to where that is.
I'm trying to say is that what I think would probably be the right way to go is to delineate the area, come up with something on a plan to say, this is the area that we're going to remove, this is the area that we're going to restore, and submit that to the planning office and get that approved by the town manager and council to say, yes, we approve this. It's not something that the board would be approving until the next meeting that would have to be noticed. So you could shorten that window up by going through that process to go through the town manager. He was the one that wrote the letter of violation. And
Well, I can't get the town manager to return a phone call to me.
I would coordinate.
Or email with me, like, at all.
I think you should coordinate with the code office, building inspector.
Right.
And he is the one who issued the letter, and I think you should coordinate with him and get him to bless what you're doing.
And I would expect that if you choose to remove the fill and restore the wetland, that there would be no need to come back before the planning board.
Well, no, but I've got to work in that 25 feet to do it, and I'm literally for my business, afraid of what John is going to do next. That's the truth. You can smile, John, but you've attacked me. You have, and I find that there's an ulterior motive to it.
I would suggest you work with a code officer and or the building inspector, and once you have his blessing, If somebody doesn't like it, I guess they can appeal it to the Board of Adjustment, but it would seem to me that would give you every right to proceed in accordance with what the two of you had worked out.
May I say that on the back of the letter, just under where we were just looking at 1 and 2, it says appeals shall be made to the ZBA. We have 1 and 2, then corrective action required by July 1st, then enforcement action, then appeals shall be made to the Zoning Board of Adjustment. Not us, not the planning board.
Well, that's if he's appealing the building inspector's decision that it's a violation. Well, I didn't think you could appeal violations.
This here is for a special use permit after the fact. That's why this is before the planning board now. To go against that would be to the zoning board.
Or the rest of the stuff.
Well, no, it's to the point that Roger was making, that the ZBA mentioned there at the end of the letter is if he wants to appeal something in that letter.
Yeah? Okay.
Any further comments? No? Could you speak to the mic, please? I'm sorry, Peter, could you speak into the mic?
Speak into the mic, yes. The erroneous flag that Sean pointed out to me, that was I was delineating the next property over. That was a convenient tree because the tree that I had used for his delineation had fallen over. So that was the closest one to it. It was about 10 feet away. It was at the border of the next lot, so its proximity, that was a slip up on my part. I was just thinking in terms of the next lot, not this lot, so that flag is not relevant.
Well, if you look at the plan, and this green line is the wetlands,
Right.
that goes quite a distance away from the driveway, and you do have the buffer delineated on this plan.
Right, yes. Yeah, that was unfortunate.
But the green line is the wetlands line.
The green line is the wetland line?
Yes.
Correct, yes. So we could certainly present a plan. We'll discuss this. We can talk to the conservation. We can make a plan of action on how to go. But if any new application that would show what's actually here or on site, at least.
But that action would be subsequent of an appeal of the ZBA, which would say they allow you to, they're siding with you on the appeal and saying, we're allowing you to go into the wetland area, and therefore you would come up with a plan on how to rectify that area. If they denied your application, you would have to clean it all the way back up to the 25-foot zone, and if they went with you and approved your claim that whatever you were claiming, then they agreed with you, then another plan would have to come forward showing the delineated area, and therefore then it would be a subsequent number 2, which would be an after-the-fact special use permit application.
So what you're saying is this project has to go to ZBA?
No.
No. If you want to clean the area out, you can clean the area out and follow number 1. But if you want to appeal that, then you can go to the ZBA. And if the ZBA sides with you, then you would come to us and file for an after-the-fact special use.
I don't agree with that. I think you'd be appealing the administrative decision of the building inspector that what you had done was a violation of the buffer, the Wetlands Conservation Ordinance. And if the Board of Adjustment ruled that it wasn't, then you wouldn't have to do anything.
I would say, to clarify some of this, there was some discussion earlier this evening that you believe there's the possibility that the grandfathered status of the lot would exempt you from the regulations against filling in the wetlands.
Not in the wetlands, no.
I'm sorry,
In the
you're
buffer
correct.
zone.
Filling in the wetland buffer.
But it's not a grandfathered lot.
No, I understand. I'm just trying to get to the end of this point.
Yeah.
If in fact you were correct that some grandfathered status would exempt you from the restriction on filling in the buffer, then you could claim potentially that the building inspector's decision was improper and you could appeal it to the ZBA.
Well, I'd really like to
That would be
avoid-
the appeal.
Yes.
Yeah.
I'm not sure that that's true, but that would be a potential course of
Well,
action.
what I'm saying, you know, not being a lawyer, I'm saying what the practice of the town has been is that these kind of impacts have been happening since this ordinance was put in, and this is the first time that this has ever come to light, and it's not making itself a precedent if it goes through this process to rectify it, if some of this area is maintained.
Yeah, I understand your point in
Yeah.
that if this has been happening in the past, and this is not the first instance, then your instance would not be the precedent. The previous ones would be the precedent. That's
Right,
the
but they
point.
just didn't get caught.
Right.
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 Yeah, so it's not a precedent until you get caught. Right, and then, yeah, so,
I'm not saying that is or isn't the case. I'm just
Yeah,
clarifying the
okay.
statement.
yes, okay. So,
You gotta,
It's got to be recorded.
Has anybody in the last 25 years been held in violations for the same thing? John, have you done anything as you've done right now in the last 15 years being part of the board, what you've done to me?
This is not.
this is not relevant.
Anything else?
I think the relevance is the fact that this is happening now and it hasn't happened in the past. I think that's relevant, whether it's personal or who's trying to get a vendetta or any of that, that's like irrelevant for sure. But, you know,
Yeah.
the fact is that this hasn't happened before.
Well, I don't think the board's prepared to admit that this has never happened before.
I don't blame you, right? You know, like, how can you possibly keep track of all the projects that have happened in Wolfeboro? I would not expect you to, and you know, things happen, and it's
So
just unfortunate. I don't know how you're going to proceed with this in the future, because you're not the code enforcement officers, right? You know,
Right.
how else does this happen? How are you going to proceed from here? Seems relevant to me that you know, one person isn't singled out for some unfortunate
But Peter,
instance.
the issue here is that there may be other cases where this same thing has happened. However, if it is drawn to the attention of the planning board through a site visit, and we don't do anything, then there's, at least, we don't ask these questions, then we are at fault. And so therefore, you know, so this is, okay, it may have happened many times that the rule has been broken, but now the planning board has seen the rule broken.
I totally understand the situation you're in, and I'm not envious of the situation you're in at all. You know, and it's a difficult situation to be in. I'm trying to work with my client to come up with some way that's an equitable solution for everyone. And I don't think we have to worry about precedent as in this case. I think okay, so can I put a hypothetical out there?
Certainly.
Okay, so you have a lot like this, or even more restrictive, where there's a building envelope that a building can fit into, a driveway can enter the property without impacting wetlands. Would the possibility be to get a special use permit to give a house 15 feet around it? Or is that 25-foot sacrosanct? You know, I just want to go,
I don't think we.
I do this for a living, right?
I
So I
understand.
need to be able
So
to talk
I-
to clients
I
on
don't
how,
think-
I know you can't answer that, but I would like to present that because it's a real life situation. And if you're going to try to build a house and it's totally surrounded by wetlands, but you can fit a building in there, you can get a driveway in there because driveways are exempt. You can how do you build a house?
You're gonna get
Leave all the trees there.
So, Mr. Kubadak, you followed the process to ask for the allowance for the pervious patio. That's the
Yeah.
process.
So you're saying that would be a legitimate application to the board to allow enough buffer around for a building site? I just want to.
You followed the process.
I followed the process.
But the process wasn't to fill all the rest of the wetland buffer, and you didn't come to us and say that that was the case.
Well,
You just came to us to ask for the exception for the pervious patio.
I am trying to understand where the limits on how to advise clients on situations like
I would
this.
advise clients not to take the excavation from the foundation and put it in the 25-foot setback. It should probably be removed from the property. That was what I would advise them to do.
But you need room to dig, get a machine in there and move things around and stuff, whether you pile it. That's not bad, and I recommend that often too, but, I just can see a scenario for an application that needs the wetland buffer to be impacted, to be able to actually construct it.
But
Sure, take the
Well,
stuff
so
off.
having the wetland buffer impacted during construction is a different situation than having the wetland buffer permanently
I
filled.
understand. I'm talking about two different things here. I just would like to get a feel for, okay, I'm on his time and I'm asking questions, but because I just want to know how to advise.
In my opinion, you cannot impact the wetland buffer before, during, or after construction
Without a special use permit.
without a special use
So you
permit.
can come in for a special use permit to give yourself enough room to build a house. And
Sure, you can come in.
You
can file
can't
it.
guarantee it'll be approved, but certainly you could apply for it.
okay.
And as you've said, every lot is different,
Yeah,
so
yeah.
it's hard to predict exactly how it's going to work out.
Okay. Just-
And there may be an instance where it's certainly impractical to build a house without impacting the buffer. That may be the case. I don't know. We'd have to look at every lot to know.
And sometimes it might come down to the size of the house or the way the process goes to dig the foundation hole. Sometimes you have to dig from one end to the other, and so you don't impact the wetland buffer area, and you can still do your trafficking in that area. So it comes down to coordination.
I just wanted to present that idea to get some kind of feedback. That, if you can't allow impact to just wetland buffer, then I guess now I know.
And I would actually suggest that there may in fact be some lots in Wolfeboro that with new regulations cannot be built on. And that is part of our regulation. And your hardship, a hardship of a particular landowner, is not necessarily something that can be followed through on. So, it just may be the way things go.
I do think we have a regulation that allows a recorded lot to have up to 1,800 square feet.
Yes,
That's a very special situation. If there's no other place, you can put a house of 1,800 square feet in buffer areas. That's another regulation.
Yeah, I'm aware of it.
And I'm aware of lots within Wolfeboro where if you look on their tax card, the lot is described as an unbuildable lot.
I have two of them.
I have declared many unbuildable lots in Wolfeboro that now have houses on them. So I don't know where those come from. Okay.
All right, I think we've exhausted the topic for this evening, unless anybody has anything else they'd like to say. All right.
Could I just burden you with one thing, or is this
Please, go ahead.
have to be agenda? I brought in a plan for the people I was with last time, a revised plan.
It's not on our agenda.
I know it's not, so could I just give it to Leanne?
Oh, certainly, you can give it to Leanne, certainly. But we can't do anything officially with it. No, I understand.
And we don't need to do anything with it.
Well, it's in a totally different place. It just meets
So this isn't this application, then?
Right, it's another application.
It's the farm.
But we approved it, so
Yeah.
it does not need to come back before us.
Right.
Just paperwork.
Come into the office.
You better discuss this under other business or public comment.
We can do it later. If you want
Yeah.
to talk to us about it as part of the meeting,
Yeah.
if you could do it at, after we finish, we have two other things. Yeah, just be a few minutes. All right, so we're going to end this preliminary hearing. The next item on the agenda is a work session for short-term residential ordinance. This topic was originally on the agenda for this meeting. However, our interim planner has a conflict and is unable to attend. It's been rescheduled to July 15th. Next item is other business, conditional use permit short-term rental application fee. The Select Board at their June 4th meeting adopted the fees associated with the conditional use permit for short-term rentals at $300 for an application fee and $150 for the public notice fee. And then the demolition review ordinance, the Heritage Commission, and Vaughn, thank you, has requested to return before the Planning Board on September 16th to discuss and present the demolition review ordinance. And now we have the public comment section of the meeting. I'm sorry?
I have one thing.
One more
is that
thing?
I have sent something to Doug about the scenic ridgeline issue.
Yeah, go ahead.
And we will be bringing that up sooner or later. In other words, it's something that was in the master plan. It was asked for by a member of the public. And so we are moving forward on that.
Thank you for the update. For public comment, Mr. Cooperdock, if you'd like to speak to... Yeah, go ahead. If you could take the microphone with you if you're going to speak. You can just pull it right out of the holder there.
Hurts. Okay, so the Fleisners last time were here.
Did they?
Shed, okay?
Yes.
For shed.
What's the address?
And
The address?
the,
This is at 9 Fawn Haven.
7 Fawn Haven
Sorry,
Drive.
7 Fawn Haven, excuse me.
7 Fawn Haven Drive. The people were watching, the owners would watch the show, and they said, we can't put the building next to the building because there is heat pump pipes coming up, faucets, water, all kinds of stuff on the outside of the building. So we moved it in a place that is attached in the corner here. It is greater setback from the wetland. You got an approval, the approval was 15 and a half feet, this is 16.
Is it the same side of the house?
No,
No, it's in the side of the
corner?
house.
Okay.
as you face the house from the street, it's on the
other
left.
side.
Yes,
Okay.
so you'll be seeing it from the road. It's on the left side. It'll be attached by a foot to the building. So it meets attachment, best I could figure there. And it has greater setback. And all the other impervious or pervious surface underneath and all the other conditions that were originally applied for would be applied. I just wanted to, since I was here, have the opportunity to show and see if there's any problem with.
So this would be,
moved.
my interpretation is that this new proposal is less non-compliant than the previous one.
Correct. Yes.
Less non-conforming.
Non-conforming, yes, thank you.
Yes.
Less non-conforming.
More nearly conforming.
Is
There you go.
this,
Thank you for the rephrasing.
Yeah.
is this something that we can do in public comment?
No.
Well, this is unofficial, so certainly we can give them
Well,
unofficial.
we
I
can't
was
give- we
asked to
can't-
bring in a new plan showing the building, the shed attached to the building for approval, for signatures. The building is attached, the shed is attached to the building. That meets that criteria. That was
The motion that we made that.
that we made.
Yes.
Yes. So that therefore, this is attached to the building.
And
It's in a
it has
greater
appropriate
setback
setbacks.
that we had before. So in my view, which doesn't seem to go over so well today, but in my view, it meets the criteria that was approved. Before I come with a copy, or I'll leave this copy for you to sign it if it's good. So,
I believe the approval referenced the plan that we had that evening.
but I was requested to bring in a revised plan.
Yeah,
And this is a revised plan.
Do you want to hear the motion?
Sure.
It was moved by Peter Goodwin to approve the Paul and Denise Fleischer special use permit application to include that the 12-foot by 16-foot structure be attached to the single-family dwelling. And under the conditions of approval, the following plan shall be amended to reflect the 12 by 16 structure to be attached to the single-family dwelling.
It is.
It seems like it
It
does.
is.
Yep.
Yep. It didn't specify the location.
It did not.
It did not.
So I don't know from a legal perspective how to proceed with this.
What would you normally do, Peter? Just take it to the office and turn it in?
Yes, yes. I
No,
would have
but then
taken
they
it
would
to the
pick-
office and seen what happened. But since I
They
was
would
coming
pick
here.
up the fact that it wasn't the same as the plan we approved.
Well,
But
wanted
the
a revised
original,
plan.
the original plan that he gave us was a detached from the house in the
That's right.
first place.
Right.
And we said if he attaches it to the house, and obviously it's in a more nearly conforming area, then there's less impact, and
And it
I
followed the rules that,
that meets the spirit of the
Seems like
motion.
this
Yes.
is a minor change that you could go ahead, make a motion, and approve the
or
plan.
just give the plan to Leanne and she
We
can
need
take
to
care of it.
No, you need the
add a
motion
condition
so
if
that
we
you can
approve
do it.
this, and the condition should be that no additional fill be placed within the buffer to the wetland.
We're on a different plan.
I know, but we have the same issue, so as
Yes.
long as it's stated as a condition, it's quite clear.
But we already voted on
don't intend
it.
the
But-
fill to go into the buffer.
But we cannot take action on this, and I don't think we need
So
to.
you don't think
Yeah,
We're just all nodding that it looks good.
No, no.
Go ahead, hand it in.
I understand that it may be that the board has no issue with the relocation of the shed, but to Roger's point, I don't think we can take any official action because we haven't noticed the butters or done anything
Right.
else.
Well, it's
Yeah.
just, I'm bringing in the plan, which I'm asking if this is complying with the approval that was issued, and it seems like it is.
My guess is that it is, and I think others on the board share that sentiment, but I would certainly want to get our interim planner's opinion on it before I give a definitive answer.
I think it meets the criteria of the approval, and it is an ministerial function that can be performed by the planning department.
Yes, I agree.
Yeah, you just got to hand it in the office.
One slight change to the plan might be in the area of the buffer. There might be a statement that no additional fill would be put there, which would therefore indicate the issue and also just be a change in plan.
I
So-
could put it under the construction sequence, I could put in another line, no additional fill be
Yeah,
placed
so
in.
I would
So-
say bring that plan into the planning department. And
And tell them you want to do this voluntarily, and
Yeah.
that you think it would be good to do that.
Okay, so I won't give this to you. yet.
You won't need any fill anyway, will you?
No. No, there's no fill needed.
All right, thank you, Mr. Cooperdock. All right, next item on the agenda is approval of minutes, the minutes from May 20th, 2025. Does anybody have any comments on it?
I do. On line 18, Peter Goodwin was absent the entire time. And that's the most I could come up with.
I did not arrive at 7:20.
You didn't jet in from Croatia?
That must have been the other meeting then.
Perhaps. All right, I'll make a motion to approve the minutes from May 20th, 2025 with the edit that Rogers approved.
So moved.
All in favor? Aye. Any opposed?
I abstain.
One abstention, thank you. The next item is approval of minutes from June 3rd, 2025.
On the first page, the third paragraph from the bottom, I think that Mr. Thurston researched the RSAs and stated his opinion. He is eligible to sit on the application. and I don't believe I confirmed that he was eligible to sit.
Anything else?
Yes, on page 2, under protection of natural resources, one of the C2s on the plan reference can be deleted. On page 3, third line, the referencing the tie-in bond, third line, I think it should read each best practice and a GIS file containing the coordinates of all BMPs, because that's, John read what was in the tie-in bond report, and that's what it said. And then on the next line, this coordinate report is the stormwater regulation.
So what's the change?
Well, first of all, it should read removal volumes for each best management practice and a GIS file containing the coordinates of all BMPs, and then in the next sentence, in accordance with the stormwater regulations.
So I'm unclear about a GIS file containing coordinates of all best management practices. What the heck is that?
That's verbatim out of the tie-in bond report, I believe.
That's a overview map of the GIS, which is you go on the town's website and it shows the layout of all your properties and all your boundaries. So basically, this boundary of this stormwater management would be
As these coordinates.
as those coordinates.
And then on page 6,
Well, wait, let me interrupt you for a second, because I got on page 5. About two-thirds of the way down the page, it reads, Doug Bruskin confirmed that anyone attending games, etc. And instead I would say it should be that Doug Bruskin confirmed with the applicant that anyone attending games. Because certainly I wouldn't speak to Brewster's practices myself.
well, then on page 6, Jim Rhines, and for purposes of clarification, I think the second sentence should read, he stated that there was a noticing issue regarding the scenic road issue, therefore that application will be continued, because it makes it sound as though the application itself had a noticing problem. And then on the relative, I think it should read, would only come into play if you are a municipality.
Where's that?
That is on the next paragraph.
Fourth paragraph from the bottom.
Yep.
And then on the second paragraph from the bottom, there should be a colon, not a hyphen, between 231, 158. And I don't know whether we can clarify this, but the abutter said that he doesn't understand how well, he stated last sentence of that paragraph, he stated the area has not been used as snowmobile trail since the property has been logged. I thought it had been, but maybe it hasn't been. Has it?
What paragraph are you on?
7.
Robert McGinnis.
About halfway down the page, on page 7.
I don't know whether that was really what he said or not, but I thought it was active this year, but. Then on page 8, the second motion, it should be 610, not 601.
No, one is the abstention.
Yep. And then on page 10, on number 4, should be the two sets be 17 by 22 instead of 22 by 34, because I thought Peter requested this.
Yes, that's right.
Wait a minute.
It is 22 by 34.
The
He
next
requested.
set
It is.
is 17 by,
23 is what he requested.
yeah, the next set is 17 by 22. The first set was 22 by 34.
On page, okay.
Yep, so page 15, you'll see the 17 by 22.
Didn't you request that on both of them?
No.
Oh, okay.
I actually think he did request it on both of them.
He didn't. I know for a fact he didn't.
I remember thinking it was an odd number, so I know it's not the same.
He didn't. I know for a fact he didn't. I swear.
Can I ask why we've got such a lengthy set of minutes for
Because
this,
we had a lengthy
One.
agenda.
as opposed to the other one that has the line numbers and all that good stuff?
We've had a change in staff. for
Again?
the minute taker.
I did these.
Thank you.
Bridget did those.
I like the line numbers.
I know. I honestly, trying to juggle
Microphone?
4 jobs.
Is Bridget resurfacing?
No, Bridget is gone. She's gone on to other things.
It's too bad. She
good.
did a good job.
Yes.
Yeah, on page 14, Roger Murray, paragraph, fourth full paragraph, second sentence should be grading, where grading is, oh, no, that's right. It should be where grading and alteration is allowed. So the is should be deleted and a D should be added to and.
Okay.
And then technically on number 7 on page 15, ensure should be spelled E-N-S-U-R-E. Which is being really obnoxious, I know.
Not obnoxious, just thorough.
I like that characterization. And then on page 17, Roger Murray paragraph, 5th line down, adequate parking and access. And then it should be absence, not absent, of environmental constraints. And on page 21, under accessory structure number 2, I believe the planning board agreed that 4 accessory structures on the tax map are lawfully existing. I don't think we approved anything. And there was a discussion and and that's it.
Anybody else? All right, I'll make a motion to approve the minutes as amended.
Second?
All in favor?
Aye.
Aye. Any opposed? All right, I'll make a motion to adjourn.
I'll second it.
Roger seconds, all in favor?
Aye.
Aye. Very good, thank you.